And we are coming live on a late Friday night, 10 minutes to midnight. We have some breaking news, and I would just do this tomorrow, but I have other breaking news as well. So it's some crazy stuff going on, man. Everything. Always, 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 they want to ruin my weekend by making me work. So let's go ahead and get this out of the way right now. The too long didn't watch of the story is that a federal judge in the Northern District of West Virginia, so he's a district court judge, has knocked down the ruling that says between the ages of 18 to 20, you cannot buy a handgun for FFL. This case is known as Brown versus the Bureau of Alcohol, Firearms, and Tobacco. So Brown versus the ATF, and this is out of West Virginia. We are joined today by our favorite reader, Flying Rich, and I think DLD After Dark will be joining us as well. So first, I want to thank Flying Rich for you coming on tonight, and let me hit the breaking news sound.
Breaking news! Breaking news!
Yes, breaking news. I'm going to go ahead and share this. I should have put this in the description. I apologize for not doing that. I'm going to go ahead and update it and put it in the description right now. Don't want to ever gatekeep, so if you want to read it yourself, you can do that as well. So I just updated it, so it should be popping up in there, and I will also paste it out in the chat as well in dark. I'm not sure how many people will be watching this because it is late on the East Coast, and I just stopped watching Die Hard to do this.
Ooh, the Gundies. What is the Gundies?
The Gundies is something that I'm nominated for out. It's going to be in Vegas on the Monday before Shot. I'm nominated for top voice of the 2A. You can vote every day, and I would appreciate your vote. But we're not here to really talk about that. So let me go ahead and just bring up the case here, and we can just buff through this, man. And DLD After Dark should be joining us soon. So let me just go ahead and adjust this. I gotta blow up the size here. And this is a big win. So let's go ahead and read through it, and let's go ahead and figure out everything going on. But before we do that, let me just thank a few people out there. Jacob, Goonbeam, best flashlights ever. Xanthi Misfit. Let's see. We have more Beta Prince, Tim Harper, Rumble Vulcan, Live Life, Ron Barr, Mike McClune, Thomas Thurman, Bill Roberts, Douglas Bonin, Johnny Barr, The Sentinel, Benchies Go Boom. Haven't seen you in a while.
Benchies.
Shar is out there. See Damian Christ, DLD After Dark, who will be joining us shortly here. A Gray, and a bunch of other people. The Supreme Edgelord, I love that. The Bear Jew, awesome name. Roddy's Roll, Douglas, Taco Syndicate. Used to be Taco Syndicate, but I guess he's Taco Syndicate and JC9. So let's go ahead and do this. I'm going to bring on Dark here too. Hi, Dark.
Hey, what's up, fellas? How's it going?
All right.
I gotta
So
be
this
quiet.
is,
I got the little one sleeping in the other room, so I'll be quiet.
this is a victory by the Second Amendment Foundation and West Virginia Citizens Defense League, which are two bang up organizations out there, and they sue the ATF, Steve Dettelbach in his official capacity, and Merrick Garland in his official capacity as a G. So let's go
first
ahead.
question, does this affect only West Virginia?
It's a district case, so it depends on how it's written. We're gonna get to that.
Okay.
Interesting.
So
Stay
basically,
tuned.
it's just like, okay. All right. So originally, right here, there's Reese versus the ATF. So let's go ahead and just read. Start with the defendant's response.
Rich, you want to take this since I get
Sure.
the little one?
For purposes of plaintiff's Rule 56 motion, the court treats these facts as undisputed. Defendants filed a response to plaintiff's statement of undisputed material facts in support of plaintiff's motion for summary judgment pursuant to this district's local rule of civil procedure 702. However, defendant's submission does not create any genuine issues of material fact sufficient to preclude consideration of summary judgment. Do you want to tell what that means?
Just keep on reading.
Okay.
I'm going to get through this.
That response
I
lists.
explain at the end of each paragraph.
Okay. That response lists 8 factual statements from plaintiff's motion, and for 6 of those simply offers statements disputed. Defendants have no knowledge as to the truth of this statement. Simply denying any knowledge about factual statements made in a sworn declaration does not carry.
Wow.
I'm sorry. Oh, ouch.
Yikes.
Oh my gosh.
Basically, like,
All
oh,
right.
we can't verify it, so you have to dismiss. What?
Liar! Pants on fire! Your Honor? Simply denying knowledge about factual statements made in a sworn declaration does not carry a non-movance burden under Rule 56. Another part of the response simply notes defendants' inability to verify factual assertions.
Man, finally somebody speaking up. That's beautiful.
That. Although the court is required to make all inferences in the light most favorable to the
Keep on
non-movant.
reading. I'm going to switch network, so I might breathe up for a second.
You're good.
Defendant's burden in facing Rule 56 motion is not insignificant, as Judge Bailey summarized. Additionally, the party opposing summary judgment must do more than simply show that there is some metaphysical doubt as to the material facts, and they cite the case that is, once the movement has met its burden to show absence of material fact, the party opposing summary judgment must then come forward with affidavits or other evidence demonstrating there is indeed a genuine issue for trial, and that it cites cases. If evidence is merely colorable,
basically what they were trying to say is, hey, you can't do a motion for summary judgment because we're not sure if what they're saying is true.
We call you a liar.
Wow.
Defendants do not even engage in speculation based on stacked inferences. They simply dispute plaintiff's factual statement, answering lack of knowledge to verify. Rule 56 demands more. Moreover, upon review of the docket, neither party engaged in any discovery efforts nor argued that additional time was needed for discovery. Wow.
I have no idea what they did. I mean, they
Can I
effed
send Christmas cards to these judges? Is that okay?
Well,
They would not be the only ones, too.
all right, here. Thus,
Thus, there is no genuine issue of material fact present here. See Rule 56.
all right,
On August 30th.
Brown. Okay, let me just say what pro se is. Brown originally filed this on his own with no help.
Really?
Yeah, no lawyer,
Wow.
no nothing.
That's gangster.
So meaning the individual say, hey, I'm suing you, and I'm
Yeah.
doing it myself.
Yeah.
So on August 30th, 2022, Brown Pro Se filed suit against the ATF, the Director, the Attorney General, Patrick Morrissey, and the West Virginia Attorney General. On that same date, summonses were issued to the initial defendants and notice of general guidelines for appearing pro se in federal court was given. The next day, the case was referred to the Honorable Michael J. Alloy, United States Magistrate Judge, for written orders or
Okay, what a magistrate judge is, you have like the district court judge and you have a magistrate judge. The magistrate judge is under the district court judge, but he's acting with the authority of the district court judge who bestows on him the authority. So it's not as high of a district court judge, but they can do a magistrate judge and it still has the same authority.
Okay. Reports and recommendations on.
But you can always say, I don't want a magistrate judge, I want an actual district judge, but I wouldn't do that.
Wow.
Okay. Or reports and recommendations on dispositive matters for decisions of any other matters that may rise. On September 23rd,
All right, go ahead.
2022, Brown's counsel filed a notice of appearance and moved for pro habeas admission for a visiting attorney.
Okay, basically, the attorney that they brought in was not a member of the West Virginia bar, but you can move to get admission as a visiting attorney. Like, for example, down in Florida, one of my attorneys is Stephen Stimbolier, who was not a member of the Florida bar, but he got visiting attorney status. The guy that defended Rich and I, one of them.
Zanty Misfit said, I think so isn't evidence.
On September 27, 2022, the First Amendment complaint for declaratory judgment and injunctive relief was filed on behalf of Mr. Brown. Wickley SAF and West Virginia CDL pleading allegations against defendants ATF, Diedelbach, and Garland. The next day, summonses were issued for the defendants because plaintiffs retained counsel. The court vacated its referral order and terminated referred status of the case.
Yeah, because he went from pro se to I have attorneys, and I have good attorneys right now.
Dang. On December 12, 2022, defendants by counsel filed motion to dismiss plaintiff's first amended complaint. Plaintiffs timely responded in opposition to defendant's motion and moved for summary judgment. Baller move. Defendants replied in support of their motion to dismiss and in opposition to plaintiff's motion for summary judgment. Plaintiffs replied in support of their motion for summary judgment and in opposition to defendant's motion. Plaintiffs and defendants have filed supplemental authority during the pendency of their motions. Thus, the motions are fully briefed and ripe for review.
Okay, basically with supplemental authority, if there's other court cases that happen from around the nation, they can file like a motion of supplemental authority. Like, for example,
like if a precedent is set somewhere else with a similar case.
Saying, hey, look, since we started this other case was decided, and this is what the other case decided.
And something like that happened with the braces, right?
It happened with the braces. It happened with pistol frames and receivers as well.
Yeah.
It's happened with a lot of different things.
Yeah.
Under Rule 12b1 of the Federal Rules of Civil Procedure, a party may move to dismiss a claim for lack of subject matter jurisdiction. A defendant challenges subject matter jurisdiction in two ways: that a complaint simply fails to allege facts upon which the subject matter jurisdiction can be based, or that the jurisdictional allegations of the complaint are not true. And
You can
a
skip all the
challenge of
legalese.
subject matter jurisdiction in the first manner, as defendants contend here, conjures the same procedural protection the plaintiff would receive under Rule 12b-6 consideration. Under Rule 12b-6, the defendant may move for dismissal upon the ground that the complaint does not state a claim upon which relief can be granted. In ruling 12b-6 motion to dismiss, a court must accept as true all of the factual allegations contained in the complaint. And case law, a court is not bound to accept as true a legal conclusion couched as a factual allegation. A court should dismiss a complaint if it does not contain enough facts to state a claim. What's my place?
To relief.
To relief
That is plausible on its face.
on its face. Plausibility exists when the plaintiff pleads factual content that allows the court to draw reasonable inference that the defendant is liable for the misconduct alleged. A motion to dismiss does not resolve contests surrounding the facts, the merits of a claim, or the applicability of defenses.
When I motion for summary judgment.
Ba-ba-boom. Summary judgment, however, is appropriate if there is no genuine dispute to any material fact and the movant is entitled to the judgment as a matter of law. The movant bears the initial responsibility of informing the district court of the basis for its motion and identifying the purpose portions of the pleadings, depositions, answers, interrogatories, and admissions on file, together with the affidavits, if any, which it believes demonstrate the absence of a genuine issue of material fact. The non-moving party must make sufficient showing on an essential element of its case with respect to which it has the burden of proof. Summary judgment is proper where the record taken as whole could not lead a rational trier of fact to find the non-moving party there being no genuine issue for trial. In case law, the court views the evidence in the light most favorable to the non-moving party and draws any reasonable inferences in the non-moving party's favor. Let's see, applicable law. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
I'm sorry.
where's that from?
Can you read that one more time?
A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. U.S. Constitution Amendment 2 in District of Columbia v. Heller. I know that guy.
Yeah,
The Supreme Court of the United
boy
States
Dick.
recognized that we like Dick, that the Second Amendment codified a pre-existing right of an ordinary, law-abiding citizen to possess a handgun in the home for self-defense. New York State rifle and pistol.
You don't have to read the cases.
Brewett decision. Yeah, but I want to read that one.
Okay.
This right, however, is not unlimited. Our nation's historical tradition teaches us that there are certain long-standing, presumptively lawful regulatory measures that the Second Amendment did not abrogate. Heller, let's see, the Heller court then set forth a two-step framework for assessing a Second Amendment claims that claimed a historical analysis with means and security. So that's a two-step method. I'm sorry.
Bruin got rid of that.
Bruin combined.
Yeah.
Bruin is text and tradition. In Bruin, Supreme Court kept with Heller, but declined to adopt the two-part approach, finding it to be one step too many. Bruin rejected any means end scrutiny entirely. Bruin affected a sea change in Second Amendment law. Amen, brother. Thank you, Clarence Thomas.
Maryland shall issue. This is the supplemental authority that that basically the plaintiffs filed. The Maryland shall issue basically knocked down the HQL, the handgun qualification license in Maryland.
Now, just out of curiosity, why do you think everyone references it as Bruin as opposed to the New York State,
It's shorter.
New York Rifle Pistol Association or whatever it is? Because
I
Bruin lost, right?
Right.
Bruin
I
lost.
assume just because it's shorter.
Yeah, because
there's other it can be referred to each other like other ways, but there's also other cases where the New York Pistol Rifle Association are plaintiffs. So it
Yeah,
can get
there's
a little
vice
bit-
versa, which you hear that acronym or
Yeah,
something.
yeah.
like
interesting.
I mean, you can
Yeah.
do it either way, but this is just
yeah,
little
just
bit
kind of find it
clearer.
fascinating that it just became dubbed as Bruin. With hey, I got nothing but love for it. I'm just curious.
Right. Bruin's holding is more rooted in textualism and originalism. Sorry. If the plain text of the Second Amendment covers an individual's conduct, then the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. To demonstrate the regulation of that conduct is within the bounds of the Second Amendment, the government must demonstrate that the regulation is consistent with the nation's historic tradition of firearm regulation. Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. As Heller also focused on the nation's traditional understanding of the Second Amendment, this was not considered a novel pronouncement. The test was that we set forth in Heller and apply today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. In Bruin, the Supreme Court emphasized that the petitioners were two ordinary law-abiding adult citizens, making them part of the people whom the Second Amendment protects.
The people are, or the courts recognize the people as 18 and over.
Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purposes.
We got to get that work done.
Right. Although its meaning is fixed according to the understanding of those who ratified it, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. Indeed, courts are instructed to use analogies to historical regulation sensitive places to determine that modern regulations prohibiting the carry of firearms in new and analogous sensitive places are constitutionally permissible.
It's saying that that a law doesn't have to be exact; it has to be damn close.
Yeah.
Mm-hmm. The Fourth Circuit recently summarized the task before this court. The Supreme Court supplied analysis covered on the Second Amendment's text and history. The court explained that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. At that point, the challenged regulation is unconstitutional unless the government can show that the regulation is consistent with this nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command.
That's Maryland shall issue. So this basically goes over Maryland shall issue. So let's just go down here.
So US 18. Oh, you want in? Where do we start?
Yeah, this is the regulation that prohibits FFLs from transferring handguns to anyone under the age of 21. So just
so prohibits FFLs from selling firearms to those who do not appear in person unless the buyer submits a sworn statement affirming he or she is 21 years or more of age. In the case of any firearm other than a shotgun or a rifle, ATF's implementing regulations, blah. Chief counsel of the ATF wrote an opinion letter in 1983 explaining that FFLs are prohibited from selling or delivering handguns to a person under the age of 21. However, a minor or juvenile is not prohibited by federal law from possessing, owning, or learning the proper usage of firearms, since any firearm that the parents or guardian desire the minor to have can be obtained by the parents or guardian.
Okay, well, here, this is a key thing. 1983, the ATF said, "Hey, you're not allowed to do this." Federally, you are allowed to own a handgun if you are 21. For example, Virginia has universal background checks. Unless you're buying a handgun from a private seller and you're under the age of 21, then you can still buy it, because in Virginia, you are permitted to own a handgun at 21.
Or even though private
Under 21.
transactions were outlawed, you can still do private transactions with immediate blood relatives. So
Yeah.
just saying.
All right, now
Because
let's go down
adults
to
have
discussion.
been,
Okay, sorry.
that's okay. Because adults have been 18 and 20 years, oh, I'm sorry, because adults between 18 and 20 years old are statutory precluded by 18 USC, blah, from buying handguns and handgun ammunition from a licensed dealer. Plaintiffs challenge their statutes are facially unconstitutional, and as applied to them, plaintiffs also request an injunction barring enforcement of the statute for the same reason. Defendants filed the pending motion to dismiss pursuant to Rules 12b1 and 12b6 of the Federal Rules of Civil Procedure and argue the plaintiff's lack of standing to bring this action, and even if they have standing, the historical background of the Second Amendment supports the government's restriction of the purchase of handguns and handgun ammunition to lawful adult citizens over the age of 21. Plaintiffs filed their motion for summary judgment and response in opposition to the defendant's motion to dismiss, contending they have standing to sue and are facially unconstitutional and unconstitutional as applied to them because the statutes are inconsistent with the nation's historical tradition.
So
Bazinga.
basically, what they were trying to do, the ATF thing was like, hey, they don't have standing to sue, which means you don't have the right to bring a case.
The court, of course, starts with a jurisdiction, particularly given defendants' advanced standing challenge to plaintiffs' claims. The judicial power vested in Article 3 of the Constitution extends to cases in controversies. U.S. Constitution or law. Federal court jurisdiction is limited to cases or controversies. Plaintiffs must establish they have standing to sue. And they cite cases.
Yeah, basically, you have to have standing to sue. So I just can't sue. I can't sue an FFL for not selling handguns to people under 21 because I'm not under 21. So
And
therefore,
you
I
are
don't have
denied.
standing.
Thus, the court must first address the plaintiff's standing to bring suit as challenged in defendant's motion. And
Skip down to Article 3.
Article 3. Standing is proven when plaintiffs have established an injury in fact, causation, and redressability. The burden to establish standing is on the party asserting it.
So
An
basically, you have to
association,
establish for you have to say, hey, I have standing, and this is why I have standing.
an association has associational standing when at least one of its identified members would otherwise have standing to sue in their own right. The interests at stake are germane to the organization's purpose, and neither claim asserted nor the relief requested requires the participation of individual members in the lawsuit.
That
Cite
means
case
since
law.
SAF and West Virginia Citizens Defense League can say, hey, some of our members are under 21. Therefore, we have associated standing because we have members under 21 that's affected by this law.
Yeah, any adult under 21, so 18 to 20, essentially, right?
Yeah. Yeah.
Defendants allege plaintiffs lack standing because they have failed to demonstrate the injury in fact. To establish injury in fact, plaintiffs must show that he or she suffered an invasion of legally protected interest that is concrete and particularized and actual or imminent, not conjectural or hypothetical. An injury is particularized if it affects the plaintiff in a personal and individual way, and it is concrete if it's de facto, that it must actually exist. Brown and Weekly contend they have suffered an injury in fact because they wish to purchase handguns and handgun ammunition from FFLs, but were precluded by statutes because of their ages. Brown and Weekly have each attempted to purchase handguns and associated ammunition from FFLs and have been turned away.
That's one of the things they have to do. They actually have to go try it. So even though that they know they're going to be denied, they go try it anyway. But they don't lie on the FFL on their 4473. They fill it out accurately, and when they get turned away, then there's your standing.
Yeah. So one before we pick it back up, one question came through. Do you want to wait till after we finish this?
Yeah.
Okay.
This are the questions that you see.
Defendants argue Brown and Weekly have not suffered an injury at all because federal statutes and regulations do not preclude 18, 19, 20-year-olds from possessing a handgun or ammunition so long as plaintiffs' parents or guardians purchase them from FFLs as bona fide gift. Defendants generally miss the point that the plaintiff's injury is clear. Plaintiffs do not dispute that 18 to 20-year-olds who are law-abiding adults and not otherwise banned from firearm possession are not prohibited from possessing handguns. Brown and Weekly's injury prompting the filing of the suit is that they cannot purchase handguns and handgun ammunition from FFLs as a result of the age-based ban.
So basically, what the ATF was trying to say is, hey, they can have their parents buy it for them and give it to them.
Defendant-specific arguments are likewise unavailing. First, the suggestion plaintiffs suffer no injury because a parent or guardian can simply purchase the gun and give it to an 18 to 20-year-old overly minimizes the plaintiff's plight. Deprivation of constitutional right is a deprivation and necessarily an injury, in fact, no matter if an easy and lawful workaround exists. Moreover, the Supreme Court of the United States previously rejected the government's reasoning in different contexts. And the Supreme Court deciding a First Amendment issue struck down a California law prohibiting the sale, but not the possession of violent video games to children under the age of 18. Like this statute, the California law allowed parents, aunts, uncles to purchase and provide games to children. Yet the Supreme Court found this prohibition on the sale of games implicated children's First Amendment rights and proceeded to strike down the regulation under strict scrutiny analysis. Brown and Weekly's injury, therefore, is not solved by the ability to receive a gift of a handgun from a parent or guardian. Holding 18 to 20-year-olds have standing to challenge the age-based handgun ban, and the statutory age prohibition violates the Second Amendment, and by prohibiting FFLs from selling guns to 18 to 20-year-olds, the laws cause those persons a concrete particularized injury, the injury of not being able to purchase handguns from FFLs. The government's suggestion erroneously draws too large a distinction between the right to possess and the right to purchase a firearm. Although the Second Amendment does not expressly protect the right to purchase firearm, that right must exist by implication if the right to keep and bear arms is to have its
full meaning and effect. All right. That's one of the arguments that a lot of people on the anti-gun side tries to make. You don't.
Yes.
The Constitution says you don't have you don't have the right to purchase a firearm. But what good is the Second Amendment if you cannot get a firearm?
Yeah.
So and the courts have recognized that over and over and over again, that the right to purchase a firearm is inferred by the right to keep and bear arms.
Amen.
So keep on going.
Facts.
Full meaning and effect, common sense logic tell us that unless one is a maker of guns, the right to keep and have a gun necessarily means that one must purchase it, steal it, be given it by another, or find one that another has lost. Wow.
Don't steal it.
Judge Payne's analysis in Frazier proved precedent. Unlike him, the court has now the benefit of the Fourth Circuit's decision in Maryland shall issue
Versus Moore, which was the 3-judge panel from the Fourth Circuit.
There, in the context of determining whether purchasing a firearm falls within the scope of a Second Amendment's protection, the Fourth Circuit found the issue not complicated if you do not already own a handgun. The only way to keep and bear one is to get one, either through sale, rental, or gift. The Fourth Circuit also dismissed the suggestion that a 30-day waiting period at issue there under Maryland law is not sufficient deprivation to run afoul of the Second Amendment. Discussing the founders' use of infringed in the amendment's text, the court left the issue undecided but noted the Second Amendment scrutiny is not exclusively reserved for laws that wholly or effectually prohibit firearm possession. This court therefore has no hesitation concluding plaintiffs have sufficiently pled and demonstrated an injury in fact. The ban, 18 U.S.C. 922, imposes on 18 to 20-year-old law-abiding citizens is more significant deprivation than the 30-day waiting period in Maryland shall issue. There, the Fourth Circuit concluded.
Okay, basically just saying that we're going to skip down a little bit. They're denying the ATS motion to dismiss right here for lack of standing.
Let's see. First, the court must determine whether the act of purchasing a firearm is within the Second Amendment's right to keep and bear arms. See Bruin, Maryland. So plaintiffs just need to show that a law regulates a course of conduct that falls within the amendment's plain text.
Right, we can skip this. Basically, it's going to get down to Bruin and say Bruin said it's necessary to imply that you have the right to acquire a firearm.
Yeah.
And this is saying that
Fourth Circuit.
We're going to skip this. This is going to say the Fourth Circuit in Maryland shall issue agreed with that and did that. So let's just go down to at the first step.
At the first step, Bruin requires a court to conduct a textual analysis that is focused on the normal and ordinary meaning of the Second Amendment language. Quoting Heller, let's see, the first question Bruin asks is whether a plaintiff's proposed course of conduct is protected by the Second Amendment's plain text. This inquiry into normal meaning of the words and phrases used is backward-looking, focused on what those words meant in 1791 when the Second Amendment was ratified. It excludes secret or technical meanings that would have been known to ordinary citizens in the founding generation.
It's basically like well-regulated. You always see the anti-gunners harp on well-regulated, but they look at regulated as the modern definition of regulated, not the definition of regulated from 1791.
Yeah, regulated in 1791 was in good standing, not a government overreach for regulation. That's very different.
Yeah, so
okay.
Look at so we can skip this. It goes down to Heller a little bit. So let's go to Being.
Being a functional prohibition on handgun buyers, the statutes at issue make it considerably more difficult for a person lawfully to acquire a firearm, including a handgun for the purpose of self-defense in the home, core lawful purpose protected by the Second Amendment. Heller, let's see. Common sense also tells us that the right to keep and bear arms includes the right to purchase them. Finding consistent with the text and logic of the Second Amendment, the right to purchase a gun falls within the Second Amendment's plain text. The court finds Judge Payne's reasoning here particularly astute and therefore persuasive. The Second Amendment courts the protection of the right of the people to keep and bear arms by providing that the right shall not be infringed. U.S. Constitution Amendment 2. The Second Amendment is unique in its use of infringed, for the word does not appear anywhere else in the Constitution despite its uniqueness. The term infringed has received little attention.
All right, so this just goes into what infringe means. So let's just go down to here.
The court's conclusion here is in line with decisions of multiple federal courts of appeal, which, when ascertaining the textual reach of the Second Amendment, have held that the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. Among these rights is the ability to acquire firearms.
And they cite Ezel versus the city of Chicago. Rhonda Ezel is a wonderful woman. She's been on our show multiple times. She is a good friend.
Oh, okay. District courts have concluded
The same.
The
It's
same.
just basically
Okay.
a district court, and then it gives you a bunch of different things.
because the substance of the challenge laws dictates that they are functional prohibition on buyers and act of purchasing a firearm within the bounds of the Second Amendment. The court turns to whether 18 to 20-year-olds are included in the people of the Second Amendment. The two-part assessment, course of conduct, and the people.
Yes.
18 to 20-year-old law-abiding citizens are part of the people whom the Second Amendment protects. The court analyzes whether, under the Second Amendment, ordinary law-abiding adult citizens between the ages of 18 and 20 years old are part of the Second Amendment protects. The court finds that they are. Initially, and Bruin requires, the court starts with the actual text of the Second Amendment, which is silent to any age. Age requirements or restrictions on the rights enshrined therein. That omission is significant when compared to other constitutional provisions. For example, minimum age requirements are constitutionally imposed on membership of the House of Representatives, 25 years of age, the United States Senate, 30 years of age, and of course, the President of the United States, 35 years of age. See U.S. Constitution, Articles 1, 2, 3, blah. Clearly, the authors of the original Constitution and Bill of Rights contemplated age restrictions during their drafting work. The Second Amendment only refers to the people.
It's saying that basically what they're saying is that since they did not state, hey, this applies only to this age, and they did in other places, therefore
it wasn't a slip up.
It wasn't a slip up. No. It wasn't a oopsie. So let's go down here.
Let's see. Other constitutional provisions lend
Actually, you know what? That basically just goes on to what the people is. What the founders said the people were, and yeah.
The Fourth Amendment likewise protects individuals regardless of age. Certainly, the context of search.
It's the same thing. I'm gonna skip because it just talks about the different. It just talks about the different places where you can infer what the age of the people is in the Constitution. And it goes on for a quite a long
Dang.
time. So go down and start right here.
Considering this analysis, the court concludes that 18 to 20-year-old law-abiding citizens are part of the people who the Second Amendment protects. Plaintiffs themselves and the activity which the federal law regulation currently prevent them from undertaking are covered under the Second Amendment's umbrella of constitutional freedoms. Thus, the burden shifts to the defendants, who must demonstrate that challenged statutes are constitutionally permissible under Bruin. And at Bruin's second step, the government must provide historical evidence that justifies the law. The government cannot meet its burden to show 18 USC 922b1,
Yeah,
920.
basically
In the normal and ordinary meaning of the Second Amendment's text protects the individual's proposed course of conduct, which the court finds to be the case here. Then the amendment presumptively guarantees the individual's right to related to firearms, and the burden falls on the government to justify the challenged regulation. In Bruin, the government bears the burden to show that the law is consistent with this, I'm assuming text and tradition, nation's historical tradition of firearm regulation. To do this, it may identify a historical analog demonstrating that its law falls within a historically recognized exception to the right to keep and bear arms. This necessarily requires the reasoning by analogy contemplated by the Bruin court. The government must identify historical firearm regulations that are consistent with the modern challenged regulation, and courts must decide whether historical regulation is proper analog through a determination of whether the two regulations are relevantly similar. And analogical reasoning, let's see,
you don't have to read that. Just
courts applying Bruin must consider whether modern and historical regulations impose comparable
okay.
burden.
You can stop that
Same
paragraph
stuff.
right there, because everybody knows what Bruin says: text, tradition, history.
Yeah. In the defendant's attempt to justify the government's regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation, they cite to William Blackstone commentaries and the long-standing state laws prohibiting sales of firearms to persons under 21. Notably, defendants argue that historically a person's age of 21 is the age of majority. Our nation's history, however, points to a different conclusion. Defendants spend time collecting state laws prescribing age barriers to the possession and purchase of firearms between the years of 1856 and 1993. However,
Okay, let's stop right there. What they are trying to do is they cannot find anything from the founding era. So they try to
1791.
move the founding era to the era of 1868. They say up until 1868 is the founding era.
Did
Which is
ATF memo go out? Because this is what the ATF's done multiple times in the past.
Yeah, well, they can't defend it by using actual founding era, so they do this.
Throw something against the wall, see if it sticks.
Yeah.
However, constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures, or yes, even future judges think that scope is too broad.
So
Yeah.
he's saying that it doesn't matter what judges think. It's what it is.
It's what it meant at the time it was written and approved.
Mhm.
At the time of the ratification of the Second Amendment, 1791, 18 was the age of majority for militia service throughout the nation, although in 1775, 16-year-olds were expected to fight in the Revolutionary War. During the War of the Revolution, 16 was the military age. In 1792, the United States Congress specified that each and every free, abled white male citizen of the respective states resident therein who is or shall be of age 18 years and under the age of 45, except as is herein after accepted, shall severally and respectfully be enrolled in the militia.
So the militia majority age was 18, and that's where you get the age of the people.
Mhm.
Okay, I saw someone that says, what, 17 people to 17 are not people. What the courts has held is the people refers to, it's different. The people and people are different terms. The people, because of the militia age, the age of majority and stuff like that is 18. That's why the courts use the age of 18. Whether it's right or wrong, maybe that can be argued in the future, but that is where the courts get that from.
So, more 18 to 20-year-old stuff. Following briefing, the government filed a notice of supplemental authority, altering the court to the 11th Circuit's decision issued the same day, National Rifle Association v. Bondi. The 11th Circuit found a Florida statute limiting the ability of 18 to 20-year-olds to purchase firearms did not violate the Second Amendment.
Okay, the 11th Circuit tried to use the data ratification of the 14th Amendment, which is 1868.
The Bondi court focused on whether the
Here it is.
ratification,
There you go.
the ratification era of the Second and 14th Amendment primarily informed its assessment of the historical tradition of American firearm regulation. As discussed, that argument is much less relevant here given plaintiffs' challenges to a federal statute. Regardless, the Bondi decision was vacated on July 14, 2023, when the 11th Circuit Court granted a petition for rehearing and decided to rehear the case en banc.
Okay, I'm going to explain that. The 11th Circuit, when they said that, and the supplemental authority referred to a 3-judge panel from the 11th Circuit. The 11th Circuit granted an en banc hearing, which means the full bench will hear it. When an en banc hearing is granted, it's like that 3-judge panel never happened. It's like a do-over. It's everything that 3-judge panel said is gone, wiped out. Doesn't matter what they said. And that's what this judge is saying.
Thus, the authority to which defendants point the court is no longer authority. To date, the defendants have inexplicably failed to update or withdraw their notice of supplemental authority, despite the fact that the 11th Circuit opinion published over 4 months ago vacates Bondi's panel opinion and dictates significant time in their papers, discounting the 4th Circuit's Hirschfield opinion for the same reason.
Wow. They cannot defend this.
Dog ate my homework?
So they're just going to ignore it and hope the judge didn't notice, I guess.
The core issue the court must answer under Bruin remains whether our nation's history and tradition contains analogous restrictions to the ability of 18 to 20-year-olds to purchase firearms. Defendants have not presented any evidence of age-based restrictions on the purchase or sale of firearms from before or at the founding or during the early republic. Defendants have likewise failed to offer evidence of similar regulation between then and 1791 or in a relevant time frame thereafter. For that reason alone, defendants have failed to meet the burden imposed by Bruin. The court once again
Sorry.
finds Judge Payne's reasoning highly persuasive. Finally, the lack of analogous evidence of founding era regulations demonstrate that the statutes and regulations at issue are inconsistent with the Second Amendment. Since the time immemorial, teenagers have been, teenagers. The general societal problem of teenage impetus and rashness far preceded the founding.
Okay. Basically, what they were saying is like, hey, teenagers don't aren't like 18-year-olds aren't you know, aren't I don't know, aren't sorry, dark, aren't you know, trustworthy, I guess.
Let's see. In summary, because the plaintiff's conduct, the purchase of handguns falls within the Second Amendment's unqualified command, and the challenged statutes and regulations are not consistent with the nation's historic tradition of firearm regulation. The court finds, blah, 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 facially unconstitutional as applied to the plaintiffs. Plaintiffs having demonstrated there is no genuine dispute of material fact and that they are entitled to judgment as a matter of law, their motion for summary judgment for the same reasons defendant's motion to dismiss is denied. So I'm sorry, I skipped defend. They win.
They win, yeah.
So
All right, there you go.
for the reasons discussed, the court denies defendant's motion to dismiss, grants the plaintiff's motion for summary judgment. Defendants are enjoined from enforcing USC 922B1C1 against plaintiffs and otherwise qualified 18 to 20-year-olds pursuant to Federal Rule Civil Procedure 54B and finding no just reason for a delay of the appeal of this order, the court directs entry of final judgment in favor of the plaintiffs and to strike this case from the court's active docket. It is so ordered. Go F yourself, ATF. Pursuant to Rule 54B, the court directs the clerk to enter separate judgment order. It further directs the clerk to transmit copies of this memorandum and opinion in order to the judgment order to counsel of record, dated December 1st, 2023, Thomas Klee, Chief Judge, Northern District of West Virginia.
Yep.
Now,
Okay.
is it West Virginia or the country?
That was knocking down everything.
The whole country.
Yeah, that wasn't just that was
Wow.
So hold on. So are you saying that this can be used as precedence for the whole country in the future? Are you saying that this one thing that occurred now 18, 19, and 20-year-olds
okay.
can walk in?
Let's go. Brian Crump, who your title is misleading. It is illegal in most states. A person 18 and 19 and 20 cannot purchase a handgun, but you can possess a handgun. Fix your title. Okay, buddy.
Beautiful last
It's
name.
about being able to purchase a handgun. Not about possessing a handgun. It's about purchasing a handgun. So the title is accurate.
I think what he's saying is that he doesn't. So if what you're saying is true, the title says breaking ban on FFLs selling handguns to 18 to 20-year-olds was struck down. Now that is exactly what happened. As far as if it's, I'm not going to personally speak on if it's just for West Virginia or nationwide, but
this is definitely nationwide.
I'm just saying, he may have misunderstood. Like this literally just happened today.
Yeah, this is breaking news.
Yeah, this is a big freaking deal. My daughter is now 21. She can do whatever she wants.
She could technically do whatever she wants at 18.
But we lack a time machine.
Based on this, I would expect the Glock 26 that was taken from me when I was 18 years old by Officer McDonald to be swiftly returned to me.
Okay.
I don't believe that'll ever happen.
I can't give my son a handgun for a gift. It depends on what state you're in.
Oh gosh, right.
How is the NFA not a registry? The NFA is a registry. It is, I believe it's the whole entire NFA is unconstitutional, but if it wasn't unconstitutional, the National Firearms Act of 1934 authorized the government to keep a registry of NFA.
Well, then they needed a constitutional amendment to do it. Go F yourself.
Can I explain how they got around that in 1934, if that's okay, really quickly?
There was a tax.
So, well, yes, but the issue is that they're always saying that the ATF cannot keep a registry of our firearms. Okay, now there are some states that have a mandatory registration of all firearms. The way that they went around this is that they categorized NFA items in 1934. So let's say originally handguns were included in this. So they were obviously removed. So short barrel rifles, machine guns, short barreled shotguns, AOWs, silencers, they categorize them as affray, which is dangerous and unusual. Because they are dangerous and unusual, they require a tax. Because they now all of this is wrong, none of this is right. All of us disagree with this wholeheartedly. However, because they're affray, dangerous and unusual, they require a tax. Because they require a tax and a background check, they have to keep a log in a registry of all of these transactions because they're dangerous and unusual to their standards, which is wrong, incorrect, unconstitutional, and none of us agree with it. I'm just saying that that's their breakdown of it.
Yep. All right. Let's go here. Thank you, BB Linimus, member for 15 months.
My guy.
We have Taco Syndicate member for 9 months.
All my people are here.
Rich, go ahead, read.
Okay, for the sake of argument, going by this standing, if a 16-year-old was given and emancipated by the courts, wouldn't they be due the same rights since they have no other means of getting them? I don't know.
It
not.
goes back to the age of the majority of the militia back in 1791. That's what the courts look at, and that's specifically stated as 18. I don't agree with it, but whatever.
I don't get what Agorizer is saying, but as CRS informed us, an array is actually an action, not certain objects.
So what he's referring to is that when they used this term affray to use it to describe dangerous and unusual firearms, affray is actually the act of doing something dangerous and unusual with a firearm, right? So if I'm just simply holding a machine gun, then the machine gun cannot be affray because that is not dangerous and unusual. Now, if I'm, butt naked walking down the highway with rubber chickens duct taped to me, holding a machine gun, then that may be dangerous and unusual.
You must have some weird dreams, Dark.
I mean, y'all never thought about that?
Yeah, and it is dangerous and unusual, not dangerous or unusual. So,
didn't I say dangerous?
Yeah,
and
you
unusual?
did. I did, but he was just pointing that.
Right on.
No.
Okay.
Yeah, no, good point that he made is dangerous and unusual.
Yeah, a lot of people get that mixed up.
Well, we also know that, like,
we already discussed that one.
If you were to go to a gun shop, do a 4473 and purchase a 44 Magnum, that's not dangerous. An AOW is way more dangerous. A silencer is way more dangerous.
Unbelievable.
All right.
So it's nationwide, yes, sir.
And it absolutely is. Everything they have is a searchable database, whether they admit to it or not.
We need an icon of like the ATF's junk getting slammed in the door again and again.
We could probably do that. We've had a series of wins, gentlemen. Like this has been some tumultuous times. We've had a series of attacks, and they are losing constantly.
A lot.
Yeah. Couldn't be happier. Obviously, we're nowhere near where I would like us to be personally. I don't think there should be any restriction at all.
A searchable database, that's what the ATF referred to as their database in the out of business records.
Yeah. AKA
which my local FFL went out of business.
So all of those Ubers, guess where they went? To the gay TF.
What do you think I'm buying guns from FFLs 3 hours away from me?
That will make such a difference.
Luckily, Dark has made more PWEDC more common use, so it's not dangerous.
This is true.
In Dark, one of your followers just was in the news recently.
Yeah, that's true. Oh, careful.
What was it? He was PWEDCing it was a semi-auto
Bodyguard 380.
Bodyguard 380. Oh.
In his beehole.
It's kind of a big gun too. I mean, it's not a big gun, but it's big.
It's not
bad.
Not one of the smallest.
It's not as bad as that dude.
I mean,
it's not as bad as that dude that had a 6-inch barrel 38
Python.
Yeah, I mean, basically, it's the Smith & Wesson equivalent. We're talking a 10.5-inch revolver up his beehole, and he had meth in his pocket. Like, bro, really?
Well,
that's crazy. Yeah. Bill Roberts says, that's not unusual. What else do you expect me to do with all these rubber ducks? Rubber chickens.
All right. Any other questions before we get out of here, guys?
Nothing that would be appropriate to say online without getting my door kicked in.
Yep.
I have All Get Home.
All Get Home?
All Get Home.
Yep.
There you go. Yeah. Rich printed a nog.
Yeah, he has the Nylog. Oh, you know what? I have a P1P on the way.
Nice.
P1P, it's going to be arriving Wednesday, the same day as my another ammo shipment. I can't stop. I can't stop.
All right. Follow Rich at Flying Rich Firearms on YouTube, Flying Rich _official on Instagram, flyingrich.com. DLD After Dark runs DLD hardware. Just Google that.
Mm-hmm.
Also follow him at DLD After Dark on YouTube. We do a podcast on Monday nights on Rumble called Uncensored Podcast. So if you just go to like rumble.com/uncensored podcast or /c/uncensored podcast, you'll find it 10 o'clock Eastern.
Where we talk the ish that you can't hear on the tubes of you.
And I will see you guys later on. I'm going to do a video tomorrow morning. Like I said, there's a lot of stuff going on, which is always. Oh, and if you did not see my short, the Fifth Circuit declined to do emergency stay on the FRT injunction. So there you go.
That was sweet. That's another good one.
Nice.
Yep. ATF has definitely been losing a lot. It's been less. They're not having a good end of the year.
I'm just wondering what they're going to do around Christmas time.
They always do something.
They always drop something.
Yep.
Always.
That's why I took the days off after Christmas.
The only thing I can say to people before we leave is to make sure you get as many ducks in a row and everything that you can in order, and make sure that you are as good with God as you possibly can be, because these are challenging times.
I started watching Die Hard, but then stuff came up, so I'm gonna watch it tomorrow, I guess.
I gotta watch Die Hard.
Invasion USA, which is my two favorite Christmas movies: Invasion USA and Die Hard.
Remember Nakatomi Plaza.
Mm-hmm.
Yeah. Thank you, Polygraph, and remember to vote for me at the Gundies. One other thing.
We could vote again. It's after midnight.
I can definitely tell you they probably are not going to be aware of this. So, and the system's probably still going to be set up to reject you. So it's
going to be a week.
It's going to be a while.
So when the gun store opens, as in like 9 a.m. tomorrow, he's about to walk to the gun shop. I mean, honestly, you can go to Pacer, print out the documents, and bring it to
they're not going to take that. Dude, you're going to hand a legal document over.
I'm just saying, highlight. Which would you rather do? Would you rather not do anything, or Yeah.
And this is dealing with the federal law. If your state has a state law, even though that's probably gonna, it's unconstitutional.
Mm-hmm.
It's probably gonna take another court case to get those.
Oh dang!
So
Chris
it's
Shoemake said that he was
thegundys.com?
unsubscribed. Yeah, I've been seeing a lot of people that become unsubscribed from me, and it seems to happen right around the time that I have several streams
Oh,
demonetized.
got it.
So, yeah, vote for Crump.
Hey, John, on the Gundy's list, how come you? Oh, does it random order? Because
Yeah.
I'm looking at your last. There you are.
Yeah,
You're
it's
like
random.
6 now.
Get right with your family. Get right with God. Stay strapped. Get
You're up against
everything.
Budbusters, you know that?
Yeah, I know. Talked to him again today.
Good. Get everything in order that you can, guys, because this is
Food,
crazy
fuel,
time.
water,
Food, shelter, security, and
precious
dildos.
metals, copper, and lead.
And brass.
Yeah, if you're going to vote, it has not reset yet, so you can go vote now. I think those guys are like 1 or 2 hours behind. So,
they're Texas.
So it's gonna flip over anytime now. So go vote now. Yeah, maybe have 1 minute, maybe you have more. I don't know. Maybe an hour. I don't know, but whatever. All right, guys.
Break
That
this
is
candy
it.
bar. I'll see y'all later.
And see you guys later.